Civil action, 34 CFR Section 300.516. General. Any party aggrieved by the findings and decision who does not have the right to an appeal, and any party aggrieved by the findings and decision, has the right to bring a civil action with respect to the complaint notice requesting a due process hearing. The action may be brought in any state court of competent jurisdiction, or in a district court of the United States, without regard to the amount in controversy. A civil action may be filed in either state or federal court. If appealed to a state court, the appeal must be filed within 30 days of the date of the due process hearing decision. A federal court may apply a similar time limit. Additional procedures. In any civil action, the court 1. receives the records of the administrative proceedings, 2. hears additional evidence at the request of a party, and 3. basing its decision on the preponderance of the evidence, grants the relief that the court determines to be appropriate. Jurisdiction of district courts. The district courts of the United States have jurisdiction of actions brought under the procedural safeguards of the idea without regard to the amount in controversy. Rule of construction. Nothing in this part restricts or limits the rights, procedures, and remedies available under the Constitution, the Americans with Disabilities Act of 1990, Title V of the Rehabilitation Act of 1973, or other federal laws protecting the rights of students with disabilities, except that before the filing of a civil action under these laws seeking relief that is also available under the procedural safeguards of the idea, the procedures must be exhausted to the same extent as would be required had the action been brought under Section 615 of the idea. Attorney's fees, 34 CFR Section 300.517 and 53A 153057. General. In any action or proceeding brought under procedural safeguards of the idea, the court, in its discretion, may award reasonable attorney's fees as part of the costs. 1. To the prevailing party who is the parent of a student with a disability or the adult student. 2. To a prevailing party who is the jus borli against the attorney of a parent or adult student who files a complaint or subsequent cause of action that is frivolous, unreasonable, or without foundation, or against the attorney of a parent or adult student who continued to litigate after the litigation clearly became frivolous, unreasonable, or without foundation. 3. Or to a prevailing jus borli against the attorney of a parent or adult student, or against the parent or adult student, if the parent's or adult student's request for a due process hearing or subsequent cause of action was presented for any improper purpose, such as to harass, to cause unnecessary delay, or to needlessly increase the cost of litigation. Funds under the idea may not be used to pay attorney's fees or costs of a party related to any action or proceeding. And Lee may use funds under the idea for conducting an action or proceeding under the procedural safeguards of the idea. Award of fees. A court awards reasonable attorney's fees consistent with the following. 1. Fees awarded must be based on rates prevailing in the community in which the action or proceeding arose for the kind and quality of services furnished. 2. No bonus or multiplier may be used in calculating the fees awarded. 3. Attorney's fees may not be awarded and related costs may not be reimbursed in any action or proceeding for services performed subsequent to the time of a written offer of settlement to a parent or adult student if a. the offer is made within the time prescribed by Rule 68 of the Federal Rules of Civil Procedure or, in the case of an administrative proceeding, at any time more than 10 calendar days before the proceeding begins, b. the offer is not accepted within 10 calendar days, and c. the court or administrative hearing officer finds that the relief finally obtained by the parents is not more favorable to the parents than the offer of settlement. 4. Attorney's fees may not be awarded relating to any meeting of the IEP team unless the meeting is convened as a result of an administrative proceeding or judicial action, or at the discretion of the state, for a mediation under Section 300.506. 5. A resolution meeting shall not be considered a meeting convened as a result of an administrative hearing or judicial action, or an administrative hearing or judicial action for purposes of attorney's fees in this section. 6. An award of attorney's fees and related costs may be made to a parent or adult student who is the prevailing party and who is substantially justified in rejecting the settlement offer. The court reduces, accordingly, the amount of the attorney's fees awarded, if the court finds that 1. the parent's or adult student, or the parent's or adult student's attorney, during the course of the action or proceeding, unreasonably protracted the final resolution of the controversy. 2. The amount of the attorney's fees otherwise authorized to be awarded unreasonably exceeds the hourly rate prevailing in the community for similar services by attorneys of reasonably comparable skill, reputation, and experience. 3. The time spent and legal services furnished were excessive considering the nature of the action or proceeding, or 4. The attorney representing the parent or adult student did not provide to the LEA the appropriate information in the due process request notice. If the parties failed to reach agreement or payment of attorney fees, then a party seeking recover of attorney fees for a special education administrative action under 20 U.S.C. Section 1415I shall file a court action within 30 days after issuance of a due process decision. 53A 153057. The above regulations regarding attorneys' fees do not apply in any action or proceeding if the court finds that the LEA unreasonably protracted the final resolution of the action or proceeding or there was a violation of the procedural safeguards of the idea. Student's status during proceedings. 34 CFR Section 300.518. During the pendency of any administrative or judicial proceeding regarding a request for a due process hearing, unless the LEA and the parents of the student or adult student agree otherwise, the student involved in the complaint must remain in his/her current educational placement. If the complaint involves an application for initial admission to public school, the student, with the consent of the parents or adult student, must be placed in the public school until the completion of all the proceedings. If the decision of a hearing officer in a due process hearing conducted by the USP agrees with the student's parents or adult student that a change of placement is appropriate, that placement must be treated as an agreement between the LEA and the parents or adult student. An agreement between the LEA